Okay, so let's continue our discussion. So we're doing sharing of profits, where I was talking about the last element, okay, which was regarding uh, the previous owner or the part owner, where I was explaining you that if suppose a person has a business which is very well established and flourished, but then suppose he's having a intention of leaving the country or maybe discontinuing, or or transferring his business to somebody, then in that case we call him to be the person who's selling the goodwill of the business. So in this case, obviously you're required to pay him the amount for the business that he has sold. But then what happens is sometimes the partners agree that we'll take over the business, but we will pay you part by part. Okay, so what will happen is they will after every year in annuity wise, they will start transferring some part of the money to them as a part of their fees for the sale of goodwill. Okay, like a consideration for the sale of goodwill. So this money also is coming from where? The profit. But because we are sharing it to them, do they become the partner in the business? No. So the idea here is very simple. Here they are telling sharing of profit is compulsory, one of the important elements. And to every person whom you are going to share the profit, we call them to be the partners. But every time when somebody gets profit, does not mean that he is a partner. Okay. Your exceptions are they're talking about when you take a loan from the bank. Okay, you have to part away your profit to the person with respect to repayment of loan. Second, employees of the organization, agents in the form of commission. So remuneration could be salary, commission, anything together. We call it to be remuneration. Then, if a partner is deceased, dead, then as a part of his share, we are required to give to his LR. His LR could be a widow or his children. Then when you're going to part away some part of the profit to them annually as a part of their share, then though they're receiving the profits, you can't call them to be the partners. And last, they talk about a person who sells his goodwill. So to repay him back as a purchase consideration, okay, then we have an agreement with them where we are going to part away the profits for 5 years, 10 years, something like that. Okay. So in this case, also we are going to give them a part of our profit only. But that doesn't cause that we are giving him what? The share of profit. So these are not considered to be partners. So though sharing of profit is one of the elements which are very, very important, it is not the only element to test what partnership is there or not. Okay. So in this, we can come to a conclusion that the true test of partnership is actually going to be mutual agency. Okay. So you can look at it now. As discussed earlier, sharing of profit is an essential element to constitute partnership. Agreed? But it is only a prima facie evidence and not conclusive. Not conclusive means only if there is sharing of profit. Do you call it to be a partnership? No, it is not a conclusive evidence in that regard. The sharing of profits or of gross returns accruing from a property by a person holding joint or common interest in the property would not by itself satisfy. Now, this we have repeated so many times. Everywhere they're telling if you are a co-owner, then also you're going to share the profit. But a co-owner's profit, is it considered to be a partnership? No. They're owning a property together, and whatever rental income, or if they sell the property, the share of profit that they're generating will be shared. So only this sharing will not prima facie make them the partners. Okay. So although the right to participate in profits is a strong test of partnership, and there may be cases where upon a simple participation in profits, there is a partnership, yet whether the relation does or does not exist must depend upon the whole contract between the parties. So whole contract means you also test whether there's a concept of mutual agency. Okay, then where there is an express agreement between the partners to share the profits of the business and business is being carried on by all or any one of them acting for all, then there will be no difficulty in the light of the provision of section 4 in determining the existence of the partnership. So can we conclude the true test of partnership is mutual agency? आकाश, आवाज को नहीं आई गई. Okay, moving on further. But the task becomes difficult when either there is no specific agreement or agreement as such does not specifically speak about partnership. In such testing, the existence or otherwise of the partnership relations, section 6 has to be referred to. And according to the section 6, where we discuss the concept of mutual agency, they say According to Section 6, regard must be given to the real relationship between the parties as shown by the relevant facts taken together. The rule is easily stated and is clear, but its application is very difficult. Cumulative effect of all the relevant facts, such as written or verbal agreement, real intention, conduct of the parties, other surrounding circumstances, etc., are to be considered while deciding the relationship between the parties and ascertaining the existence of partnership. So they're telling there are a lot of parameters based on which you have to understand whether partnership is there or not. First, you look at agreement, whether it is there. It could be oral or it could be written. Then you look at the real intention. What is the intention? To come together, run the business, share the profit. Then sometimes we say it need not be what? Expressed. It could also be by the conduct of the parties. You should look at the conduct of the parties, surrounding circumstances, etc. And everything taken into account together will decide if the partnership is there or not there. Okay, then. Finally, we discuss about agency. This is a very well discussed concept of agency here. So even in the essential elements of that contract, when you're going to mention, or essential elements of partnership, when you're going to mention about agency, the last part, any one of them acting for all that part, I would recommend you write this answer only. Okay. Existence of mutual agency, which is the cardinal principle of partnership law, is very much helpful in reaching a conclusion in this regard. Each partner carrying on the business is principal as well as the agent of the other partner. So the act of one partner done on behalf of the firm, that is all the partners, binds all the partners. If the element of mutual agency relationship exists between the parties, constituting a group formed with a view to earn profit by running a business, a partnership is deemed to have been existed. So there is a business from where they're sharing profit. And the idea is one person is acting in two capacity, one as principal, other as the agent. Then here you can have a conclusive evidence. It is a partnership. Okay, then. Existence of mutual agency, which is cardinal principle. They have repeated this point, okay? This point is repetition. So this part is very, very important to remember. Okay, all this English which they have given here, no? These are not to be by-hearted and all that. You only have to pick up the main important points. Like in agreement, you can say oral, written, implied. Okay, you can also tell about how partnership is created by agreement and not by status. So HUF, okay, the Burmese Buddhist husband and wife, they share profits because of the status that they have. But in partnership, even if there is the son to the partner, he will not automatically become the partner. There has to come an agreement. Then sharing of profit is one of the prima facie evidences that yes, there is a partnership, but that is not the conclusive evidence because there are a lot of people in the organization who receive profits from the business. They will not become the partners in the partnership. So they've given us 4 for our discussion. Then they say there are a lot of other circumstances that will help us understand whether the partnership is there or not there. Okay, like you can look at the agreement, like oral, written, conduct of the parties, business, sharing of profit, and many other circumstances. But if you look at one of the most important concept, that is mutual agency, that is the criteria for deciding whether partnership exists or does not exist. Okay. Now, in Satyaranjan Das Gupta versus Dasriyan Muzaral, what they have told us, in Santiranjan Das Gupta versus Dasirayan Murzamal, following factors weighed upon the Supreme Court to reach the conclusion that is there is no partnership between the firm. So these 4 were the pointers picked upon to decide whether partnership is there or not there. And because of these 4 points, we understood there is no partnership here. So which are those? Parties have not retained any record of terms and conditions of the partnership. That is, there is no agreement. Next, partnership business has maintained no accounts of its own, which would be open to inspection by both the parties. So books of accounts are not maintained. That means business. Okay, if it is a business, obviously books of accounts has to be there. No account of partnership was opened with the bank. So obviously, right, there should be one common account of the partnership with the bank because individually they're all like partners, but they have to operate one account together as a firm. That is all together one partner, all together one firm. So they should have a account in the name of the firm, all partners together jointly owning it. No written intimation was conveyed to the Deputy Director of Procurement with respect to newly created partnership. So this is actually not required also because registration is not mandatory. But here in this case, it is adopted one, wherein we say these are the following elements that they took into account for the purpose of understanding there is no partnership. For us, out of this, the most relevant points was there was no terms and conditions discussed. So there was no agreement. Second, they were not maintaining any proper books of accounts. Okay, so business could be doubtful. Second, we talk about is they don't have a common bank account. Okay, so joint owner bank account is not there. And finally, they have not communicated Deputy Director of Procurement. Okay, these are the points wherein in this case study they have told establish that there is no partnership. Okay. Now, let's do the next part, which is quite a simple discussion. Partnership distinguished from other forms of organization. The first one, you should not have a problem, absolutely. So, as always, we do in the class, you have to cover on the right side and we look at the left side and only understand the basis of it. Okay, so first one, what is the legal status? Okay, is partnership having a separate legal status? The answer is no. Partner and partnership firm are one and the same. But in company, there is a separate legal existence. So company will be different, member will be different. Agency. In every firm, a partner is going to be the agent of the other partners. But in the case of company, is one member a agent of other member? Will the act of one member bind the other member? No. So because of that, there is no concept of agency coming in case of a company. Distribution of profits. In partnership, distribution of profit is compulsory because it is the most important element of partnership. But in companies, distribution of profits happen in the form of dividend. But companies are at the liberty to decide whether in the current year they want to give dividends or not. If they want to give dividends, they can give it. So it will be in the form of dividend that they get returns on. Okay, then. Extent of liability, very important discussion. In partnership, it is unlimited liability. That means in case to repay the debts, the partners have to even attach their personal property if it is insufficient to pay off the debts. In companies, we don't have that concept. We have studied that depending upon the type of the company, the liability will be limited. So we have company limited by shares, company limited by guarantee. In company limited by shares, we say the liability is limited to the unpaid value of the shares. But in company limited by guarantee, we say the liability of the company is limited to the amount of guarantee which every member is contributed to pay at the time of winding up. Okay, and there could also be an unlimited company. Then comes to property. Okay, in case of partnership, a concept which you're going to discuss in the unit 2. What happens is if there is a building in the name of partnership, meaning is if there are three partners A, B, and C, and is there a building in the name of the firm, that means A, B, and C are joint owners of the firm. Okay, like if there's an agreement entered, okay, then the sale deed will be in the name of A, B, and C. So when it is in the name of firm, it simply means all the partners. So basically, this property will become the joint owner of all the partners. So there is nothing called as a partnership having its own property, partners having separate property. No. If all the partners together are holding a property for the business of the partnership, then we call that property to be a partnership property. In case of company, the concept is different. Members' property is different. Company's property is different. Because company is having a separate legal status. Can company own its own property? Can I say Reliance Industries holds that building? The building belongs to Reliance Industries? Yes. Correct? So the idea is company will have it in its own name. Transfer of shares. What is the meaning of share? It is your capital contribution that you have done based on which you are getting the share. Correct? Now, in case of partnership, if suppose there are three partners, A, B, and C. Now, what A says, whatever every year I have to receive my share of profit, I will give it to Z. So basically, he's trying to transfer his share to this partner. Question is it allowed or not? This we are going to have a detailed discussion in the unit 2. But because it is mentioned here, you should be knowing. When one partner decides to transfer his share to another partner, to another person, that is third party, who is not a partner, then in that case, he's allowed to do. But he should take the consent of all the partners. He requires the consent of all the partners. Okay, then. In case of shareholding, you know it very well. Companies, one of the characteristic is transfer of shares. So public company, you will have free transferability, but private company, there will be transferability, but restricted transferability by its articles. Correct? Then. After that comes to management. In partnership, who manages the business? It is the working partner. Correct? But in case of company, who manages the business? It is the people who are the representative of the members. So in the general meeting, the members are going to elect their representatives, whom we call them to be board of directors. And here, board of directors will manage and owners are going to be different. So there is a separation of ownership, there is separation of management. But in case of partnership, there are some partners called as active partners. These are the ones who are going to manage the business. Okay. However, understand, if you say active partner is there, okay, then active partner will manage. If you don't say any partner is active partner, then it is understood that all are active partners. So if there is no contract to the contrary, if express agreement is not there, express agreement means a deed. Because in the deed, you have to mention who is an active partner and all that. So the deed is silent. We say all partners are active partners. Like we have this concept, right? If you don't have a profit sharing ratio decided, that means all the partners are going to share profit and losses equally. Like that, if suppose you have not decided if there is any active partner, then understanding of law will be all the partners are active partner. So every partner will have a equal right to enter into the management. Okay, then registration. Company by itself is called as incorporated association. If you look at the definition of company itself, it should be registered under companies law or any other previous act. So company registration is mandatory. Partnership registration is optional. So whether you want, you do it or do not do it, but obviously recommended to do it for all the future disputes to be ignored. However, in unit 3, we'll be discussing about the concept where why registration becomes so important even if it is optional. Okay. So it is not compulsory. Here it is compulsory. It has to be registered under Companies Act 2013. Winding up. In case of partnership, winding up, court judgments are all not required every time. You can have a voluntary decision of all the partners taken together and they can agree to dissolve. But company is created by law. So dissolution also happens by law only. So court has to pass an order for the winding up of the company. So court is nothing but for us, National Company Law Tribunal. So here they have given the name as Company Law Tribunal. Yeah, National Company Law Tribunal. Okay, it is NCLT. Or you also know that if the registrar removes the name from the register of companies, then also your company is over. Okay, then. Number of membership. In partnership, I told you, the Partnership Act will not tell how many members you require. But in Companies Act, there is a section called as 464 of the Companies Act, wherein they are mentioning that if any association has 50 members and they're still continuing as partnership and not converting into company, either private or public, then that will be considered to be illegal. So indirectly, they're telling if you want to have partnership, maximum partners that you can have is 50. After that, you're compulsory required to convert yourself into either public company or private company. So there, indirectly, they give a hint that the maximum number of partners that you have in a partnership firm are 50. Okay, so here they say according to 464, the number of partners in any association will not exceed 100. But I told you, Act will not be applicable to us, rule will be applicable. So as of now, in the rule, the number is 50. So for your exam, you have to remember 50 is the maximum number of partners. However, in case of company, what is the criteria? Depending upon the type of the company. If it's a public company, you require minimum 7 members. In case of private company, you require minimum 2. And in case of OPC, it is minimum, maximum only 1. Then duration of existence. Partnership, obviously, the duration may be discussed or may not be discussed, but the duration will get impacted if there is death of a partner, insolvency of a partner. So if there are 3 partners and out of 2 die, or out of 3, 2 die or 2 become insolvent, automatically the partnership will dissolve. Okay? So that is the meaning. Unless there is a contract to the contrary, death, retirement, or insolvency of a partner can result in dissolution of the firm. Company does not have that problem. Whether members come, whether members go, whether member leaves, transfers a share, okay, insolvency of a member, death of a member, nothing is going to impact the continuation of the company. Company enjoys perpetual succession forever. One after the other, somebody will succeed. Okay, then. That's the concept of company versus partnership. Okay, because we know company very well, you'll be able to understand the difference between partnership and company also very clearly. Now we have partnership versus club. Now these are not the party clubs. Now these are not the clubs that we see in the movies and all. Those are not these are kind of clubs. These clubs are basically a kind of association of people where they try to provide some kind of benefits to the members. Okay, like we have the concept that you'll be hearing about Lions Club, Rotary clubs, and all that. So basically, these come together for the purpose of providing some recreational facilities to their members, or they provide some amenities to their members at a concessional rate, or it is like a place where people can actually join in together, socialize together. So club is having a different concept altogether. Okay, so members of the club do not start owning the property. To give a simple example, there is this concept of Club Mahindra. Okay, so this is nothing but they're all the chain of hotels that are together, wherein they are formed in the form of a club. So if you want to be a part of it, you have to take a membership of it, and then you'll be able to enjoy all the benefits. Some benefits for the members will be at free of cost. Some benefits will be at concessional prices. You'll be getting some kind of amenities which others don't get. Okay, so basically the club is working for the benefit of the members. Okay, so because it is a chain of hotels, people who are going to be a part of it will be getting a benefit, as they'll be getting some kind of stays which are going to be completely free. Some services like gym, spa, and everything will be at concessional rates to them. Okay, so a lot of things the members will enjoy. However, members also are responsible to pay their own fees. That means they'll be paying the annual membership fees. They'll be having lifetime membership fees. Every year, renewal fees will be there. Okay. Now, suppose if I am the member of this club. Now, in this case, do I mean the hotel belongs to me? The swimming pool belongs to me? No. The point is, I am allowed to only enjoy. I'm allowed to only take the benefit out of it, and for which I'm actually paying a consideration. So I will have absolutely no insurable interest in the properties of the club. So they are working for whom? Benefits of the people. That's the only reason. But partnership is not like that. Partnership, every partner will have interest in the property of the business. They are going to share the profits. Okay, so it's a different concept altogether. And club, the very idea is recreation. Okay, people go for holidays. People have some free time how they want to spend. Like you have cricket clubs also, where people go to play. It is nothing but a recreational facility given. But in partnership, all this concept is not there. It's this thorough business that you're going to carry on. Okay, so that is the idea. In partnership, we say it is association of persons formed for earning profit. It should be a business carried on by all or any one of them acting for all. In case of club, what we say? Association of persons. What is the object? Not to earn profit, but to promote some beneficial purpose, such as improvement of health or providing recreation for the members. Improvement of health is there are clubs for only yoga. There are clubs only for, gym and all that, cricket, playing clubs. All these clubs are meant for that. Recreation is the example I gave you of Club Mahindra, where people go for holidays. It's a change. Okay. So they're all meant for not profit oriented. Okay. They are member oriented. Then comes to relationship. In partners, every partner has a relationship with each other. But in clubs, one member will not have any contact with another member. You don't have any relationship with them. So no binding effect of two members. Persons forming a club are called as members. A member of a club is not the agent of the other member. So what one member does, other will definitely not be responsible. Interest in the property, I explained you very well that if I'm a part of any club, do I say this particular property is mine? This particular benefit is mine. This cricket club, all the cricket things are mine? No. I'll have no interest in the property of the club. Partner has the interest in the property of the firm. Dissolution, a change in the partner of a firm affects its existence. So if two partners, one goes, obviously it will affect the existence. Member, no. You don't pay the annual membership fee. You don't pay the membership fee regularly, or you want to actually voluntarily come out of it. Will it affect the club? The club will continue. Okay. So clubs, you should be knowing that long term, you should be obviously a part of one of the clubs and all for recreational facilities. Clubs are ranging from very small number to crores and crores of membership. So today, one of the places where people actually find recreation. Okay. Then partnership versus HUF. So for all of you, a basic understanding about HUF will be Hindu undivided family, meaning is a joint family. Okay, this law is exclusively a Hindu law. Okay. Now, when you see a joint Hindu family, okay, then you will be seeing a grandfather, okay, having three sons, okay, then they are married, they have children, grandchildren. So big chain is created, and they'll be running one family business together. So this is nothing but the business together by the entire family, okay, which is run mainly by the head of the family, that is Karta. Whether it is female or male, it does not matter. Today, both are allowed. Male also could be Karta, female also could be the Karta. The top, the highest, the eldest member of the family will become the Karta, and every other person we call him to be co-parsoner. Okay, so everybody will have the right in the property, everybody will have the right in the share of profit, but everything will be divided by whom? Karta. So decisions will be taken by Karta. Distribution of profit will be done by Karta. Okay, the sole control will be to whom? The Karta only. So partnership versus Hindu undivided family. So we have discussed one concept that partnership happens by agreement. Okay. But HUF happens by status. I told you this thing that once you're born in that family, you'll become what? The member of the HUF. So it is created by status. The moment you take birth, you are a part of that family. Okay, you become the part of HUF. Now, death of a member, death of a partner, first of all. When a partner dies, can it affect the existence of the partnership? Till now, every time we have discussed, yes. On the contrary, a death of a member in the Hindu undivided family does not dissolve the business. So if the big joint family, one person dies, in fact, even Karta dies, will HUF still continue? Yes. Then management. In partnership, I told you, unless the contract says otherwise, all the partners will be having the right to participate in the management. But in case of HUF, who manages the business? It is Karta. The right of the management of joint family business generally vests in the Karta, the governing male member or female member of the family. Just for your knowledge, okay, before 2005, it was compulsory that only a male member could become the Karta. Only male member. Okay, so the senior most male member could be the Karta. So the grandparents, grandmother, grandfather, and they have 3 children. What happens is after grandfather dies, directly the eldest son would become the Karta. Now it is not like that. Now, can the female member of the family also can become the Karta? Yes. So the grandmother definitely can take the position of what? Karta. So this was, see here, they've given you the case reference also. The amendment in Hindu Succession Act 2005 entitled all adult members, now all adult members, whether it is Hindu male or female, to become co-partners in HUF. They now enjoy equal rights. Okay? Of inheritance due to amendment. On 1st February 2016, Justice Nazmi Waziri gave a landmark judgment which allowed the eldest female co-partner to become what? Karta in the HUF. So I told you there is going to be one head and then there will be a family. So these all we call to be what? Co-partner. So what will happen is if Karta dies, one of the co-partner will become the Karta, right? So earlier this was only male. Now they say all. So male and female both. Okay. Then after that, we have authority to bind every partner mutual agency concept. So will he bind the other partners? Yes. Now Karta's part is what, what decisions Karta take, Karta alone will be responsible. The other members of the family will not be bound by it. Okay. The Karta or the manager has the authority to contract for the family and the other members in the family. So will he be able to take decisions for the family together? Yes. Liability. In a partnership, the liability of the partner is unlimited. Okay, here it is very interesting. Liability of only Karta will be unlimited. And all the other co-partners will be responsible only to the extent of the profits that they have in the business. Same concept here above also you see. Karta only is taking decisions. Karta only is taking decisions for the family members also. Similarly, so whose liability will become unlimited? Karta's liability will become unlimited. Everybody else's liability will be limited only to the extent of their share of profits in the business. So whatever they're earning, that much they have to give back. But personally, have they to give back? No. It is only the Karta who will become having unlimited liability. Okay, then. Calling for closure of accounts. Okay, now what happens is sometimes there are 3-4 partners. So what we require in partnership is that all partners should agree for dissolve. And then partnership can be dissolved. But sometimes what happens is 4 partners are agreeing. But one is adamant, I don't want to close. Now in this case, any which way, they can't close it because all have to agree, then closure can happen. So what they say is, if this one partner is not ready for the closure, okay, or maybe this only one partner wants the closure, remaining 4 does not want, then what option does this one partner have? That he will apply to the court, file a case, and require the court to ask the partners to close the books. Okay, so like this. A partner can bring a suit against the firm, that is all the other partners, provided he also seeks dissolution of the firm. So you can ask for the accounts, provided he should seek dissolution. And on the separation of the joint family, a member is not entitled to ask for the accounts. I told you in the beginning itself, division of the property, who will do? Karta. So do you have the right of asking why and all that? No. The member is not entitled to ask for the accounts of the family business. A member will have no right. Co-partner has no right to understand about the accounts. But in case of partnership, every single partner has the right to the accounts. So if the other partners say no, can he go to the court and file a case against it? Yes. And he can ask for the accounts closure and he can also seek for dissolution in that case. Governing law, very easy. partnership is governed by Partnership Act 1932 and this HUF is governed by the Hindu law. Minor's capacity, obviously in case of partnership, we know a minor cannot be a partner. But can he be admitted to the benefits in the partnership? Answer is yes. On the contrary, in case of HUF, I told you the moment you take birth, you become the member. So is minor allowed to be a member in HUF? Yes. The moment you take birth, you're 1 hour old. Okay. So obviously, are you still a member of that HUF? Yes. So minor concept doesn't work in the case of HUF. A minor can become the member by the incidence of his birth. He does not have to wait for the majority. Continuity. A firm will be subject to continuity if it is discussed in the partnership agreement. So if there are 3 partners, if one die, can the 2 continue? Yeah, if they have an agreement. Usually what happens if one partner dies or one partner becomes insolvent, usually they go for dissolution. But is there a possibility that other partners still want to continue? Yes, they should have a contract to the contrary. Okay, other usually by death or insolvency, dissolution happens. Continuity, member is going, HUF will continue till it is divided. The status of joint Hindu family is not thereby affected by death of the member. This we discussed. Number of members in case of partnership, maximum is 50. In case of HUF, you can't tell now, okay, we reached a limit. Now family cannot grow further. No. Unlimited members. Okay. So it's a joint family. Obviously, there is going to be a cycle, one after the other, one after the other, one after the other. Family is going to grow. So only because you want to restrict the number for HUF, can you stop birth in the family? No. So there is unlimited. Share in the business. Okay, so partners do get share in the business compulsorily. Okay, here in HUF, no co-partner will have a definite share. Definite share as in it is the karta who is going to decide how much each partner has to get or how much each co-partner has to get. So no co-partner will have a definite share. Obviously, interest will be fluctuating one. And how fluctuating one you understand? If there is birth in the family, the share will come down. And if there is a death in the family, the share will increase. So can you ever say a standardized structure of receiving profit is there in the HUF? No. It is purely depending upon the addition of the members and deletion of the members from the family. So it is fluctuating one. Birth will reduce the share. Death will increase the share of every other member. Okay, so it is not a fixed one. Okay, next. So that is about HUF. Okay, very simple discussion. You can just have a quick reading here. Definition is quite simple. No, sorry. Mode of creation, status. Death of member will not affect. Management only by karta. Authority to bind karta can take decisions for the family. Liability of karta will be unlimited. Okay, no member can call for the books of accounts. He has no right. Governing law, Hindu law. Minor can be a partner. A minor can be a member of the HUF. Continuity, obviously it is continued unless it is divided. Number of members, unlimited. Share is fluctuating one. Birth and death will definitely impact it. Okay. Next, easy discussion again. Partnership versus co-ownership. Okay. Now, co-ownership is very simple. There is a building. This building is jointly owned by A and B. These two are considered to be co-owners. Now, this property they have given rent. The rent received will be divided by them. So, are they actually running a business? No. They have an agreement? Yes. Are they sharing profit? Yes. But are they running business? No. So, they are only co-owners. And now you tell me, I told in case of A, B, C being partners, if A wants to transfer the share, he compulsorily requires the consent of all the partners. Correct? But in case of who I took it as X and Y. In case of X and Y, who are joint owners, if Y wants to sell his share, will he take permission of X? No. Your share, you do what you want to do. Got it? So very simple concepts here. Partnership arises out of contract. Obviously, agreement is there express or implied. Co-ownership either arises by agreement. So we both go and take a property together. Or it could also obtain by inheritance. How inheritance? Very simple. There is a grandfather. Okay, what he has done? In his will, he has written that the property that I leave behind, the legacy that I'm keeping behind, will be jointly owned by 3 of my sons. So what happened here? Because of his death, these 3 sons got inheritance from their father. And because of that, they became the co-owners. Correct? So can it happen by inheritance also? Yes, an inheritance operation of law. Then implied agency, in case of co-ownership, there is no implied agency. One person is not binding other person at all. But in partnership, is there a mutual agency? 100%. Transfer of interest in the partner, can it happen? Yes, but compulsory with the consent of all the partners. But in case of co-ownership, can you transfer your share without the consent of the other co-owner? Yes, it's your, you do whatever you want to without consent of the owners. Association is a generalized term. Any people coming together, group of people coming together is called association. An association could be for charity. Association could be for not doing business, absolutely. Okay. So anything could be an association. So it could not have mutual agency and all also. They might not be for the purpose of profits also. So only association does not make you a partnership. So it is going to be different. The partnership compulsory 2 or more persons should come together, but for business, sharing profits and mutual agency. Here it is not like that. Association involves social cause also, and there is no necessary motive to earn profits. The intention is not to enter the business for gains. Partnership is compulsory to run business and earn profits. This is charitable societies. Okay, improvement schemes, or building corporations, or mutual insurance society, or trade protection association. So basically, NGOs, NPOs. These are never partnership. Always association. Okay, that's the idea. So these are the different forms of organizations that we have discussed in detail. Okay. Okay, now we come to a very interesting discussion for exam, very important. We are going to talk about kinds of partnership. Now, all the students who have a very bad problem of reading question wrongly, you'll be having a great problem here because 2 questions can come in the exam. One, partners. Second, partnership. There are different type of partners. There are different type of partnership. So there are altogether 4 types. Okay, partnership at will, partnership for fixed period, particular partnership, general partnership. Okay, so one is based on duration, one is based on the business, not business, extent of business. Okay, now I'll first explain you these things, and then we'll go to the important concept for exam, that is partnership at will. Now, go with the word partnership for a fixed period. The word itself has the definition. Meaning is, if you and I become partners and we say, let us sell books together, but we have decided that we are in the city only for 3 years now. So till the time we are in the city for 3 years, let us sell the books together, earn the profits, and share it among ourselves. Is this partnership? Yes. But we have decided this to be done only for how many years? 3 years. So in this case, we call ourselves to partnership for a fixed period. So once the 3 years are over, our partnership will come to an end. Our partnership will be over. So when we are having a partnership only for a particular period of time, after which we will cease to be a partner, the partnership has to dissolve. We call that partnership to be partnership for a fixed period. Okay, that is a simple one. Now comes to extent of business. That is depending upon how much business you do together. We have 2 types. Particular, general. Now what is particular? Only this one particular thing we are doing together. No, everything we'll do together. Now, simple example. You and I come together that only for one particular, we will meet only for exhibition purposes, where if exhibitions are there, we'll go together, we'll sell in the exhibitions, earn the profit and share among ourselves. After that, again, when the exhibition comes, that time only we're going to come together. So every exhibition that we are going to meet is a particular contract that we'll enter. So once the exhibition over, partnership also over. So once the particular adventure, once the particular idea, or once the particular purpose is accomplished, partnership comes to an end. Okay? Then it happens only for the particular period, or particular, not even period, a particular business. Okay, sale in the exhibition. Only for that we are coming together. Or two partners come together only for serving one client. After the client's work is over, these two are again separated. So they came together only to help that client together, only one particular purpose. So that we call it to be what? Particular purpose, particular partnership. But then we don't decide that, okay, we're doing for him or not. Two people come together and they say, every client we are going to handle together. So whether it is one client or 100 clients come to us, all these clients we are going to handle together. So consultation, doing audits, everything together we are doing. Then in this case, have you defined only for one particular purpose we are coming together, or generally we are going to do everything together? Generally. So in this case, extent is not particular objective, not particular client, not particular consultation only. It is everything we'll do together. So when you and I come together and tomorrow start a CA firm, wherein we are going to run it together for all our clients. That means we are doing which partnership? General. But then suppose you have your own firm and I have my own firm. But there is a client who has come to me, wherein your expertise I would be requiring to assist. So I come to you and say, look, I require your assistance for this particular area. So for this respective client, I will do this part. Please could you help me do the other one? So we came together only for that client for that one particular task. And after that, over. So we will share the fees of only that particular client. But will we share the fees of all the client together? No. When we are required to share the fees of all the clients together here, then it is what? General partnership. Okay. So extent will decide what it is. Now comes partnership at will. So fixed period is easy for a particular period. Particular is for a particular business, particular adventure. After that, partnership over. General, not particular. Everything together we are going to do. Generally, everything in the business is done together. And the business together is managed, profits are generated and shared. In partnership at will, what is the idea is, first of all, if you look at that partnership agreement, there will be absolutely no term. So if you look at all the terms, there will be absolutely no term which will decide duration of the partnership, which will not decide. That means nowhere they'll say, when will the partnership come to an end? Nowhere. There is no provision only here with respect to determination of the period. If we look at the English here, no fixed period has been agreed upon for the duration, and there is no provision made as to determination of partnership. So they don't decide only it is fixed period, it is for long period, or maybe it is for particular purpose or not. Nothing is given. There is no way to determine. So when you look at the partnership agreement, again bring it here, there is no provision here for period. There is no provision here for determination of nature of partnership. Look at the words. Duration or determination of partnership. Nothing is given. So you're doing business without any understanding till where we are going to continue or what all we are going to do together. But here they say it is at will. That means if suppose A, B, C come together with a agreement where they have not decided how long they are going to be together, or they have not decided what kind of partnership it is, but they have decided that when any one partner wants to retire, when any one partner wants to leave, he will simply give a notice to all the other partners. And the moment he gives notice, the firm has to dissolve. Understand, remaining partners can't continue. The firm has to dissolve. That kind of partnership, we call it partnership at will. Let's start together. Kab tak? We don't know. How long we are going to do? We don't know. What kind of partnership we are running? Don't know. But we know we will continue. But the moment one partner decides that he wants to leave, he has to give a written notice to all the other partners that he is willing to go, retire. The moment he gives notice, can you say remaining partners will continue? No. The firm has to dissolve. That kind of partnership, we call it to be partnership at will. Now understand the concept. Fixed term partnership, which I gave the example of 3 years. If suppose the partners have gelled up very well together, if they're enjoying or if they're doing the business very well, they're very comfortable, their business is going very good, they're in good terms with each other. So they decided, let's continue. So after fixed term, 3 years later, when they're going to continue, don't you think now they're going to continue for a period that they have not decided? Don't you think now they're not able to determine what is the nature of their partnership? Now, don't you think when a fixed term partnership continues after a fixed period, they also will become partnership at will only? Correct? So that is the idea. So here, if you look at it, what is partnership at will? Where a partnership at will is a partnership when there is no fixed period where regarding duration. Second, no fixed, first of all here, no fixed period for the duration. And second, no provision. What is the meaning of provision? The content written in the agreement, we call it to be provision. No provision is there to determine partnership. What kind of partnership? Because this is partnership, no? Partnership at will, partnership for fixed period, particular partnership, general partnership. This you're not able to decide. Correct? So you're not able to determine the partnership. But then they say these two conditions must be satisfied before partnership can be regarded as a partnership at will. Because understand, the moment you say duration, it comes under this. The moment you tell determination of partnership, it will depend upon either particular partnership or general partnership. So once it falls in any of the three criteria, it will never fall here. Correct? So it should not fall in these three. So it should not define the duration, neither tell the determination of partnership. Then only it can be partnership at will. So these two conditions compulsory have to be fulfilled. But where there is an agreement between the partners, either for duration of the partnership or for determination of the partnership, it cannot be partnership at will. They repeated the same point. Where a partnership entered into for a fixed term is continued after the expiry of such term, it also becomes partnership at will. Is the concept taken home correctly now? So if you are going to continue after partnership for fixed period, then obviously you'll become what? Partnership at will, because then the period is not decided. A partnership at will may be dissolved by any partner by giving notice in writing to all the other partners that the intention of dissolving the firm. So what is the important point you should not forget in the exam? Partner has to give a notice in writing to all the other partners about his intention to dissolve. Clear? Okay, then. Remaining all you know it very well. Partnership for a fixed period where a provision is made by a contract for a duration of partnership. The partnership is called as a fixed period. So contract is nothing but agreement is entered. Whether till it is for 3 years over. It's partnership at fixed period. It is a partnership created for a particular period of time. Such a partnership obviously comes to an end after the expiry of the fixed period. And if it continues, it becomes at will. Particular partnership, a partnership may be organized for the prosecution of a single adventure. I told you, for a prosecution means for completion or for doing, we can say, or taking up. Okay? A single adventure or as a conduct of continuous business. So if it is a continuous business, like I gave the example of CA firms together, it becomes general. But if it is only for a particular adventure, single, it becomes particular. Okay? Then, where a person becomes a partner with another person in any particular adventure or undertaking, it is called as particular partnership. And the moment that is over, partnership will dissolve. A partnership constituted for a single adventure undertaking, subject to any agreement, will be obviously dissolved on the completion of the adventure undertaking. Then general partnership is what? Wherein I gave the example of a CA firm where two CAs are working together for all the clients. So is it going to be continuous in nature, general in nature for all the clients, all the services? That is general partnership. Where a partnership is constituted with respect to a business, in general, it is called general partnership. For example, two brothers running a grocery store together, general partnership. A general partnership is different from a particular partnership. In case of a particular partnership, the liability of a partner extends only to particular adventure. I told you, when you have a exhibition run together, then only with respect to that exhibition, you have assets and liability shared together. But when it is a general, is everything taken together? Yes. But it is not so in the case of general partnership. General partnership is different from limited liability partnership. Obviously, how can you compare that? Because ultimately, partnership are unlimited liability. Limited liability partnership is different story. Here compulsory only maximum 50. Here it is unlimited. This can be unregistered. This has to be registered. Okay, so different stories altogether. Okay, so that is regarding different type of partnerships. Okay, now moving to the next one, partnership deed. Very easy. Now, partnership deed is, I told you, agreement could be oral or written. So if it is a written agreement, Are you going to tear a paper from the book and write it on that and make it a partnership agreement? No. You will take a stamp paper. And on the stamp paper, all the terms and conditions will be written. So when this agreement is in writing and is duly stamped, this agreement becomes what? Deed. So can I say a partnership agreement in writing, which is duly stamped, is a partnership deed? Okay, yes. Now in this, what you have to write? Now we know that wherever partnership deed is silent, law will come into picture. So for example, we say if interest on capital is not given, the law says no interest on capital. If they say on partner's loan, if interest is not decided, then we say at the rate of 6% per annum. If PSR not decided, the law says equal. So basically, law is having a provision with respect to everything which is absent in the partnership. So do you have any hard and fast rule? These should be the content of the partnership deed? No. Understand, agreement could be oral. So can they make a hard and fast rule? These should be the content? No. So completely, it is the choice of the partners to decide what all should be bought in the agreement. So what can they bring? Name will be there, duration will be there, business of the partnership will be there, name of the partners will be there. If they have separate active partners, you should give their names. Then you will talk about how can a partner be admitted, how can a partner get retired, what will be the PSR, what could be the interest on drawing, interest on capital, interest on a partner's loan. Will a partner get salary? Will a partner get commission? So whatever you want to decide for your business, everything could be bought in the agreement. So these are all a list given illustrative in nature. It's purely illustrative. So it is not a mandatory one. It is illustration of examples given to you. Whichever you want to put, you put. Don't put, law will come into picture. So you can look at it. Partnership is a result of an agreement. No particular formalities are required for an agreement of partnership. It may be either in writing or it could be orally. We know that. But it is desirable to have the partnership agreement in writing. Very obvious. Today, what we are talking, tomorrow I might say, मैंने कभी बोला ही नहीं. I have never said. So could it be a reason to bring more disputes in the future? Yes. So to avoid the future disputes and all that, we preferably bring it in writing. The document in writing containing various terms and conditions. The document in writing containing various terms and conditions with respect to relationship of the partners to each other is called as what? Partnership deed. Then it should be drafted with care and should be stamped under Stamp Act 1899. Where the partnership comprises immovable property. See, when a partnership has an immovable property, no, then the question of oral agreement is not allowed. Try to remember this thing, Contract Act. In Contract Act, we have something that some essential elements to be complied with. Like we say, that in essential elements of valid contract, certain formalities to be complied with. Okay, so in case of we talk about insurance there, we talk about immovable properties there. There, without writing, it is not going to happen. So obviously, if the partnership involves a immobile property, oral agreements can't happen only. Okay, it has to be in writing because if you look at Contract Act in general, they say if immovable property is involved and all, then oral things we don't permit. It should be compulsory registered. So because of that, if a partnership is based on a immovable property, okay, or has immovable properties, obviously registration will become what? Mandatory. Where partnership comprises of immovable property, this you can collect two essential elements of valid contract, other essential elements to be complied with. Okay, because there we see ultimately partnership is a part of Contract Act only. So if nothing is given here, we take it from there. So it's one of the examples there. So they say when the partnership comprises immovable property, the instrument of partnership must be compulsory in writing, stamped, and registered under Registration Act. So your partnership deed may contain the following: names of all the partners, nature and place of business, when did you start the partnership, what the duration of partnership. Very important, I forgot, capital contribution, PSR, how admission retirement happens, rates. If dissolution happen, how will you settle the account? Will a partner get salary commission or not? If you want to expel a partner, remove a partner, how should you remove? Can a partner be expelled because of fraud and all that? All of these things are right. A partnership may add also and delete also any provision according to the needs of the firm. So I told you it is illustrative in nature. Okay, so you can add or you can even remove. Okay, now Now moving on to the next one, types of partners. So now types of partners are going to be multiple. They are very simple discussion. Now, just a new term for your knowledge. Active partner is also called ostensible partner. Okay. So you can look at your active partner, ostensible partner, also called as working partner. Okay. Then you'll have nominal partner. Sub partner has been removed from your syllabus. It is not there. Outgoing partner, sleeping partner, dormant partner, partners in profits only, incoming partner, partner by holding out. Okay, so you'll not have difficulty in understanding, but language should be understood properly that every person, okay, every person can become a partner only by agreement. Because I told you partnership is purely by agreement and not by status. So every time you begin the answer about who is a partner, who is an active partner, a partner who has become a person who has become a partner by agreement and who actively takes part in the management of the business. That is called active partner. Is the point very clear? Like that. Similarly, who's sleeping partner? A partner who becomes a partner through agreement and who does not actively take part in the management of the business. You got the idea? So beginning should be who has become partner by agreement. So it's a person who becomes partner by agreement. Similarly, for sleeping partner, you'll say person who becomes partner by agreement. Because every time you have to do as per the agreement, then you can become the partner. Now listen to the concept of active partner. In case of active partner, he's also called as actual partner, ostensible partner, working partner. All these names are for the partner who is actively running the business. Now, when if active partner leaves, okay, when active partner is leaving, don't you think people are actually dealing with the active partner only on regular basis? Creditors are dealing with him. He's dealing with the customers. So people connected with the business are all talking only to whom? Active partner. So don't you think it will be very important that when an active partner leaves, retires, basically resigns, he has to compulsory give public notice? Reason is people are dealing with him. People believe him to be a partner. He's a face seen. So people know, okay, he's a partner, so we are dealing. So most of the time, active partner is the reason for all the dealings happening. And so if you do not tell the outsider that I'm no longer a partner, then he will be under an impression you're still a partner. So you understand, you're not a partner, but understood to be still a partner. Then you'll fall in the step of partner by estoppel and you'll become liable. So what they say is it is the duty of the partnership firm, or you can say the active partner, that when he retires, he has to compulsory give public notice. And understand, if you retired on 1st of April, until 10th of April, you have not given public notice. Okay? Then your resignation is still not considered to be valid. Meaning is, to the third party, will you still be partner? Yes. Meaning is, suppose in this period, if anything has happened, you are actually not a partner, but you are representing yourself to be a partner in the eyes of whom? Third party. So don't you think you will that time cease to be a partner, but you're still looking as a partner to the outsider? You will fall into the shoes of partner by estoppel? Yes. So even for these transactions towards the third party, you will become liable. Okay. So it is compulsory that active partner, when he resigns, he has to give public notice. If he does not give public notice for third party, he'll still continue to be a partner. So he'll falls in the position that he's not a partner, but a partner. So he'll be liable to the third party for all those acts. So he'll become partner by estoppel until the time he gives public notice. Okay. It is a partner. It's a person who becomes partner by agreement and he actively participates in the conduct. This you already know. He acts as an agent for all the other partners, okay, in the ordinary course of business. So basically, regularly, he only goes to office. In the event of his retirement, he must give public notice in order to absolve. Absolve means free himself. Free himself of the liabilities for acts of the other partners done after his retirement. So you look here in my example, I said 1st April he got retired. 10th April he is giving public notice. If suppose he had given the public notice on 1st April only, then after his retirement, all that happened, would he be free? Yes. But he will not be absolved until the time he give public notice. So even for these acts which happened after retirement, he will continue to be liable to whom? Third party. Clear? All right. Then comes to sleeping partner, also called as dormant partner. Remember, dormant company, inactive company. So similarly here, it is a person obviously who becomes partner by agreement, but reverse, does not take active participation in the business. So tell me, is the public aware of a sleeping partner? No. Sleeping partner doesn't come in the first phase of the firm only. So whether he is leaving or is there, third parties are not affected by it. So will he have to give public notice? The answer is no. Sleeping partner is under no obligation to give any kind of public notice when he is going to retire. So they are called sleeping or dormant partners. They share profits and losses and are liable to third party for the acts of the firm. So understand is ultimately partner. So he will obviously get profits. And to third party, will he be liable? Yes, because he also mutual agency, no? One partner acting for all. So when the active party is acting for all the partners, and in one of the partner, he also is there. So will he be liable always to third party? Yes. They are, however, not required to give public notice of their retirement. Logic is simple, they are not seen, no? So he'll never step into the shoes of estoppel. Estoppel is not a concept for him. Okay? Now, nominal partner is a concept which is the only place where profit share is not there. So, there are famous people, like sometimes celebrities will be there, sometimes some renowned people for their work and all that. They will associate themselves with a firm, and the firm will be allowed to use their name. Okay? But these people will actually have no interest in that business. They will not even have any profit share. But then you wonder, then why will they come? The point is they'll get fees. And the fees will be very high. And for that they will do. But the problem here is what, because they're acting as partners. If something goes wrong, to third party, they will become liable. They will become liable. Okay? And why they take this risk? Because the fee which is there, very, very high. Okay? So in Instagram and all, you must be seeing paid partnerships and all. This kind of actors, actresses do that. A person who lends his name to the firm without having any real interest. Okay? Neither they share profits. He is not even entitled to share the profits of the firm. Neither he invests. Does he invest money? No. Nor takes part in the conduct of business. He is, however, liable to third parties. So if you take all the points here, lends his name? Yes. Without having any interest? Yes. Not entitled to share of profits? Yes. Does not take part in the conduct of the business? Yes. Usually they do only advertisements only and promotion only. Okay. Liable to third party? 100% yes. This is most important. And instead of fees shared, they'll get what? Fees, which are exorbitant numbers. Okay. Now, partners in profit only. Many students have a misconception that suppose if A, B, C are partners, and suppose B is a partner only to receive profits. So what they understand, that yes, B will get profits, but we will never be liable to have losses. This is wrong. Understand, B will be liable when losses happen, but only to the extent of the profit that he got. So for example, there is a contract with Z that we have entered. Okay, wherein the firm earned 30,000. Okay. So each partner got 10,000 maybe. I'm just assuming equal, okay? Usually in such cases, equal won't happen, but assuming. So now what happened? Later, due to some breach, okay, a case was filed and they had to repay back, refund. So this is a loss now. So in this loss, understand, did you get earlier something from here? To that extent, you have to return back only. So they will be liable to the extent of the profit that they have derived. So when I say partners in profit only, I only say they will not be personally liable like other partners. Other partners, if it is not sufficient, no, they have to attach their personal assets also to pay off the debt. But this partner will not be personally liable. But will he be liable to the extent he received? Yes. What I got to that extent, I'll give only. But personally, I will not be liable. So don't have a mindset that he will never be liable to losses. Wrong. He will be liable to losses, but to the extent of the profit that he got. Personally, he will not be liable. So if you look at it, a partner who is entitled to share the profits only, correct? Without being liable for the losses is known as partners of profit. But you should not know only till here. And also liable to third party for all the acts of profits only. For all the acts of profit. So who is the third party for me? Z. So did he give profits? Yes. So to third party, will you be liable also? Yes. To the extent up to profit received. And also liable to third party for all the acts of profits only. So initially, if there was a loss, my liability is not there. But initially, there was a profit. And with that same third party, now we have to repay as a loss. Then whatever I earned from that, to that third party, will I be liable to pay that share of profit back? Yes. So entitled to share profit only, not share liable, not liable for losses, but liable to third party. In my example, Z, for all the acts of profit, which was 10K. Okay, then incoming partner is a new partner. So compulsory firm should be in existence. Incoming is where not you're forming partnership. Partnership is already there. So incoming is you are coming to an existing firm, but your liability will begin only from the date you became a partner. Okay. So firm was from 2010 maybe. You became partner in 2012. So your liability will be only from 2012. For these 12 years or these 2 years that are there, you will not be liable absolutely. Okay. Unless we have some tripartite agreements and all, which will study unit 2. A partner who is admitted as a partner into already existing firm. This is very important word. So formation of partnership is not your incoming partner, your partner. But in an existing firm, if you enter, then you're incoming partner. Okay? Obviously, with the consent of all the partners, everything will happen through agreement, and agreement means all the partners. And they're called incoming partner. Such a partner is not liable for any act of the firm done before his admission. So these 2 years, he was not be liable. Mr. A joined as a partner on 10th September 2021 in the firm MNQ Associates, which was existing from 10th July 2017. Mr. A will not be liable for any act of the firm done before his date of joining, that is 10th September 2021. Outgoing partner, same concept. Outgoing partner will be when? Don't say firm is dissolving. No. When firm is dissolving, all the partners are leaving. Partnership is coming to an end. Outgoing partner means the remaining partners are going to continue. So A, B, C are partners. A wants to retire, but B and C want to continue. Then you call him to be outgoing partner. If all three are leaving, it's called dissolution. A partner who leaves a firm in which the rest of the partners will continue to carry on the business is called as retiring or outgoing partner. Such a partner will remain liable. Obviously, suppose he's retiring on 10th April 2022 and the firm started in the from some time back. Okay. That means all this period, what happened? Will he be liable even later on? Yes. So even if there's a debt due in 2023, but this belongs to 10th April 2022 before. So even today, will he be liable? Yes. Though he ceases to be a partner, for this debt, which actually belongs to that period when he was a partner, it will still continue to be liable. So for everything, he'll be liable. And they're telling you will continue to be liable until you give public notice. And you know very well it's only for which partner? Active partner. Okay, so just for your knowledge. Here they're telling such partner remains liable to third party for all of the active until public notice is given. So basically here they should be telling actually active partner because sleeping partner public notice is not required. Now partner by holding out. This is very easy. We do it every time. A person who is not a partner but is represented to be a partner. He does not deny also. And third party believes him to be a partner and extends credit. If all these conditions are fulfilled, to this third party who has extended credit, will he be liable? The answer is yes. Okay. So partner by holding out is also known as partner by estoppel. When a man holds himself out as a partner or allows others to adopt it. So either he is representing himself or letting the others believe it without denying it. Okay. Or allows other to do it. He is then stopped from denying the character he has assumed and upon the faith of which creditor may presume to have acted. हाँ, हाल 5 मिनट नहीं नको. Okay, so you can see here, when a person represents himself or knowingly permits himself. Okay, this is, you're telling or this you're letting others know to be represented as a partner when actually he's not. Then he is liable like a partner of the firm to whom anyone who acted on the faith of the representation that he made. Credit means for extended credit. It could be any facility, it could be any loan, it could be any supplies. So they have credited, given some credit to you. Then obviously to that third party, you'll be liable. A person may by himself or by his words or conduct have induced others to believe that he is a partner or even allowed to represent himself as a partner. The result of both is identical. So whether you represent or let others believe without denying, and you don't deny. Okay, then in that case, to that third party who has given the credit, will you be liable? Yes. Okay, then. Now look at that. X and Y are partners in a partnership firm. X introduced A manager, as his partner to Z. A remained silent. Z, a trader believing A as a partner, supplied 100 TV sets to the firm on credit. Federal supplies also are correct. After expiry of the credit period, Z did not get the amount of TV sets sold to the partnership firm. Z filed a suit against X and A for the recovery of the price. Here in the given case, A, the manager, is also liable for the price because he becomes the partner by holding out. Remember section 28, okay, if you can. It is only the person to whom the representation has been made and who has acted thereon has the right to enforce the liability. Meaning is, this person who sold the TV set, did you represent to him and did he give TV sets? To him, you'll be liable. Okay, so it is compulsory, relationship has to be established. You did and he believed that. You must also note that for the purpose of fixing liability on a person who has, by representation, led another to act, it is not necessary to show that he was actuated by the fraudulent intention. Okay, so the fraudulent intention there, not there, does not matter. But did you present yourself to be a partner? Did you appear to be a partner? Didn't you deny? Okay, you could deny. Did you do? No. Whether your intention is fraud or not, that all doesn't matter. Did the other person believe you to be the partner? Did he extend the credit? Yes. So in that case, you'll become what? Partner to him. You'll be liable to him. Okay, this is exactly what I explained to you. Active partner is required to give public notice. And until they give him time public notice, will he also be liable to third parties as a partner? Yes. So he's not a partner, but assumed to be a partner towards the third party. So he also will become partner by estoppel after his retirement till the time he gives public notice. The rule of section 28, that is estoppel, is also applicable to a former partner who has retired from the firm without giving proper public notice of his retirement. In such case, a person who, even subsequent to the retirement, that is after retirement, gives credit to the firm on the belief that he was a partner, will be entitled to hold him liable. So in my example, if A, B, and C are partners, A is active partner and he has retired. He is not given public notice and third party still extends the credit, then he'll be liable.